Betzetic is an LA-based community nonprofit that provides justice, stability, and hope to those experiencing economic and social disparities. They provide free legal services, educate community members with the powerful knowledge of their legal rights, and use our collective voice to reform systems. Their vision is to achieve equitable access to justice so that everyone can meet their essential needs and lead fulfilling lives. Each year, Betzetic works with over 1,000 pro bono attorneys and volunteers like us to assist more than 65,000 individuals and families, regardless of their ethnic and racial backgrounds, ability to afford an attorney, religious beliefs, immigrant status, or gender identities. Small businesses are a key part of local economies and infrastructure. Betzetic's Small Business Development Project supports small business owners through legal representation and educational resources. Betzetic's Small Business Development Project partners with pro bono attorneys like us to provide free legal education, resources, and one-on-one legal assistance to low to moderate income small business owners and entrepreneurs. Betzetic's Small Business Development Project can help small business owners and entrepreneurs with forming a business, leasing commercial space, understanding contracts, fair employee practices, protecting their intellectual property, and more. Contact Betzetic's Small Business Development Project by visiting lalegalhelp.org or calling 866-375-9511. They offer services in different languages.
This video was brought to you in partnership with the City of Los Angeles Economic and Workforce Development Department and Betzetic Legal Services. Betzetic is an equal opportunity affirmative action employer.
The Economic and Workforce Development Department's goal is to steer economic development in a manner that yields thriving businesses and creates job training and career opportunities for the City of Los Angeles. EWDD works every day to deliver a strong and committed workforce, maintain sustainable neighborhoods, and profitable communities throughout Los Angeles. Get more information at ewdd.lacity.gov. The City of Los Angeles Economic and Workforce Development Department, or EWDD, funds 10 business source centers across LA City. Business source centers offer free business consulting and technical assistance to help startups and operating businesses with permitting, access to capital, and marketing, among others. Services are provided at no cost to LA City business owners and resident entrepreneurs. Get more information at the link on your screen. Thank you for viewing this educational video. The information provided in this video is intended for general informational purposes only and should not be construed as legal advice. While we strive to present accurate and up-to-date information regarding small business laws and regulations in the state of California, laws are subject to change and may vary based on specific circumstances. Viewers are strongly encouraged to consult with a qualified attorney for advice tailored to their individual situation and to ensure compliance with all applicable laws. The content presented herein does not establish an attorney-client relationship, and we assume no liability for any loss or damage incurred as a result of reliance on the information provided in this video. You should decide which course of action is best for your small business after thoroughly discussing your case with a qualified attorney. Thank you.
My name is Jonathan Hyman.
And I'm Craig Cook.
And we are partners in the Los Angeles office of Kenobi Martins, an intellectual property and technology law firm.
Our firm is Betzetic's pro bono partner.
Today we'll be discussing intellectual property. I'll be discussing trademarks and copyrights.
I'll be discussing patents and trade secrets.
When we talk about intellectual property, or IP, we're referring to trademarks, copyrights, patents, and trade secrets. Today, I will be discussing trademarks and copyrights. Intellectual property can help protect investments made in companies, products, and/or services, developing content, and creating business innovations. IP protection can also protect market share, create unique selling points, and help your products and services stand out in a competitive market. A robust IP portfolio can also help build a strong brand and consumer reputation. Intellectual property can also be used as security for loans and investments. Some investors even look to IP as a way to ensure their investments will be safe by acting as a barrier to entry. Securing intellectual property rights can also help avoid liability and ensure you're not infringing others' IP rights. If you do not adequately protect your intellectual property, your business and the investment you and others may have made in your business can be at risk. For example, competitors may copy or imitate your products and services, leading to a loss of market share. You could also be at risk for costly legal fees to defend your rights. Oftentimes, IP rights are needed to combat counterfeit and lookalike products and pursue takedowns on online platforms. You could also miss out on other opportunities like licensing and franchising deals. Some IP rights can even provide protection against importation by recording the registration with U.S. Customs and Border Patrol, which can bar entry of infringing products. A trademark or service mark is any symbol or device capable of identifying and distinguishing its owner's products or services from those of others. These can be words, logos, slogans, product shapes, which are called trade dress, colors, sounds, and even scents. The most common types of trademarks are word marks and logos, but shapes, like the shape of the classic Coca-Cola bottle, sounds, like the sound when Netflix launches, or the laugh of the Pillsbury Doughboy, or colors, like pink for Owens Corning insulation or brown for UPS, and even smells, like the scent of Play-Doh, are protectable trademarks. To be hyper-technical, trademarks are used on goods, and service marks are used on services. However, in this video, I will often refer simply to trademarks, but these principles apply to both trademarks and service marks. A trademark represents the goodwill and reputation of a product and its source. Its owner has the right to prevent others from trading on that goodwill by using the same or similar trademark on the same or similar products in a way that is likely to cause confusion as to the source, origin, or sponsorship of the products. Not all marks are created equal, and marks exist on a continuum of strength. However, before we get into the legal issues with a mark, we want to discuss the business and legal attributes of a good brand. The business attributes of a good brand focus on whether the mark is appropriate, credible, appealing, relevant, memorable, enduring, and easy to pronounce. But the business attributes of a good brand focus whether the mark is protectable and available. As I mentioned, marks exist on a continuum. Where a mark falls on the continuum determines the mark's inherent strength. At one end of the continuum are fanciful marks, which are the strongest marks and are afforded the highest level of protection. On the other end of the spectrum are the weakest marks, which are generic marks or terms entitled to no trademark protection. In between are marks with varying degrees of protection. Generic terms or marks are marks that are the name of the goods and services. If a mark answers the question, "What are you?" it is a generic mark. Examples of generic marks are Cherry Stout for cherry-flavored beer, software for computer software, Apple for apples, and shoes for footwear. Commonly used words or abbreviations in an industry may also be generic. Generic marks are not entitled to any protection and have no trademark significance. A slight misspelling of a word will not turn a generic word into a non-generic mark. Descriptive marks are marks that describe the goods and services to which they are applied, or the characteristics thereof. Geographic and laudatory terms such as best, good, high often fall into the descriptive category. It is not necessary that a term describes all the purposes, functions, or characteristics of a product to be considered merely descriptive. It is enough if the term describes one significant function, attribute, or property. Examples of descriptive marks are After Sun for after sunning lotion, Chapstick for lip preparation in a stick, and Wine Barrel Ale for beer made in wine barrels. Descriptive marks are afforded weak protection and require consumer recognition or secondary meaning to be protectable. A slight misspelling of a word will not turn a descriptive word into a non-descriptive mark. The next category on the continuum are suggestive marks. These are marks that suggest the goods and services to which they are applied, or the characteristics thereof. Such marks take a mental analysis or a multi-step reasoning to get from the mark to the goods or services. Examples of suggestive marks are Sweet Tarts for candy, Orange Crush for orange drinks, Citibank for urban banks, and Coppertone for suntan oil. Suggestive marks are afforded strong protection. The next category on the continuum are arbitrary marks, which are real words that are in common use but have no real meaning or connection with the goods and services to which they are applied. Arbitrary marks do not describe or suggest the goods or services to which they are applied or the characteristics thereof. Examples of arbitrary marks are Apple for computers. So while Apple for apples would be generic, Apple for computers is a strong arbitrary mark. Another example is Google for a search engine, Sun for banks, and Shell for gas. Arbitrary marks are afforded very strong protection. Lastly are fanciful marks, which are made-up words that have no real meaning and have been invented for the sole purpose of functioning as a source identifier. Examples of fanciful marks are Clorox for bleach, Kodak for film, and Exxon for gas. Fanciful marks are the strongest marks. In addition to the inherent strength of a mark based on its placement on the continuum of trademarks, the strength of a trademark can be evaluated based on the number of users of similar marks. The more parties using a mark, the weaker the mark becomes. If you think of the United States Patent and Trademark Office, or the PTO, register, and the marketplace conceptually as a pie of rights, if there is only one user of a mark on certain goods or services, that user's piece of the pie is much larger, and the rights are stronger. However, the more crowded the registered marketplace becomes, with users of a mark or a similar mark, the smaller each user's piece of the pie becomes, and the harder it is to object to new users of the same or similar marks. In addition, a mark which has been used and registered for a wide variety of goods and services by different entities is considered a weak mark, in the sense that it is difficult to enforce outside the specific field of its owner. On the other hand, an uncommon mark may be considered a strong mark because it is usually more broadly protectable against the users of the same or similar marks in related fields. The protectability of a mark can also be influenced by the fame of the mark, which can be indirectly determined by the extent and scope of use. The more the mark is used by the owner, the stronger the mark may become. Thus, a mark which is used minimally in a small geographic area may be considered weaker than marks which are used widely in a large geographic area. Oftentimes, new business owners select descriptive marks because these marks are easier to market, even though they are weaker and harder to protect. The risks of a descriptive mark are that competitors can use the same or similar terms to describe their products or services and dilute your marketing message. You have a limited ability to enforce unless you acquire secondary meaning, and you can spend more resources enforcing, registering, and protecting the mark than you actually spend on branding. While there's no requirement that you search a mark, it is a very good idea to do so. Searching provides a snapshot on whether the mark is available and protectable. The goals of searching are to manage risks, which will lower the risk of a lawsuit, receiving a cease and desist letter, or another objection, lower the risk of having to rebrand, and the other goal is to manage costs. Will the trademark registration process be costly? Is a third-party objection likely? A search helps us assess these three areas: risk of conflict, whether you bump into anyone else's rights, likelihood of registrability, whether you can register your mark, and the protectability or scope of protection, whether you have broad rights to enforce your mark. Whether you decide to search a mark and how much searching you conduct will depend on the importance of the mark and the risk to the company. For example, if a mark is easy to change, then your risk tolerance is high, and you could address a claim for infringement by changing the mark. But if you're launching a new brand and spending a lot of money on signage or materials that are difficult to change, then your risk tolerance for a claim would be very low, and you'd want to conduct more robust searching. We look at searching like walking into a room with the lights off. Searching is like turning a light on to see what's in the room. The more searching that is done, the brighter the light, and the more likely we'll be able to know if we are bumping into anything that could prevent your use or registration of your trademark. If the mark is an important mark, a formal search looking at both filings at the USPTO and each state trademark database, as well as a search for unregistered rights, should be conducted. At a minimum, you should check the USPTO's website, which has a search feature, conduct some online searching for the mark, proposed goods and services, and any planned expanded goods and services, as well as looking at social media handles and domain names. In the United States, trademark rights are developed by being the first good faith user of a mark in commerce. Such rights immediately arise under the common law in the geographic areas where the use and reputation of the mark have been established. If you only have used a mark in California, you may only have common law rights in California. These common law rights are likely not broad enough to stop someone from using the same mark on the same goods or services in Florida. However, the exclusive right of the trademark owner to expand the use of the mark to other geographic areas can be preserved by obtaining a federal registration of the mark. Like a federal registration, a state trademark registration can also be obtained to provide prima facie evidence of the exclusive ownership of the mark in a particular state. Most businesses form a corporation or file a fictitious business name statement. Neither the certificate of incorporation nor the fictitious business name statement gives a business the right to use a trade name that is likely to cause confusion with a trade name, trademark, or service mark that was previously used by someone else in the same area of trade. There is no requirement to register your mark, but there are many advantages to doing so. A federally registered mark is presumed to be a valid mark, and the registrant is presumed to have the exclusive right to use the trademark throughout the United States on the goods and services listed in the registration. A registered mark will also be revealed in searches conducted by other businesses in their effort to avoid selecting marks that may conflict with those of others. In addition, only federally registered trademarks or service marks may use the Circle R Federal Registration symbol. You can also record your registration with the Customs and Border Patrol to prevent infringing goods from being imported into the United States. After 5 years, the registration may become incontestable, which significantly limits the grounds on which competitors can attack the registration. An application for a federal registration may be filed before a mark is used in commerce, assuming the applicant has a good faith intent to use the mark. But actual use must begin prior to the issuance of a registration. Marks may also be registered in each of the 50 states. The advantage of a state registration vary according to the laws of each state. Most states require that you use a mark on goods or services before applying for the registration. A California trademark registration, for example, is usually faster, less expensive, and less difficult to obtain than a federal registration. It also allows its owner to sue infringers under several California statutes that offer advantages not available under federal law. A California trademark registration, however, has no force or effect outside of the state of California. Trademarks can generally last as long as they continue to be used as a source identifier for goods or services. A federal registration can be renewed every 10 years, but you must file a declaration of continued use between the 5th and 6th year after registration in order to maintain the registration. Trademarks are an important asset of your business. They represent the goodwill of the company and act as a source identifier for your unique products and services. They help protect the investment in your company. Trademarks go beyond just logos and words. They can include not only names and logos, but also slogans, product shapes, called trade dress, colors, sounds, and even scents. Not all trademarks are created equal. Try to pick trademarks that are inherently strong, that are suggestive, arbitrary, or fanciful. You should also search a mark before filing or adopting it. Conducting a trademark search is critical to avoid legal disputes, forced rebranding, and wasted resources. While registration is not mandatory, it is highly recommended and has big advantages. A copyright is a right granted to the creator of a written, musical, or artistic work that protects the expression of an idea. Its purpose is to prevent others from copying the work without permission. Because copyright protection requires originality, it bars others from copying copyrighted works to create substantially similar works. It is possible, however, for two very similar works to be independently created, with each author owning a separate copyright. For example, if two strangers stand next to each other and each takes a photograph of the same scene, each would own a copyright in his or her respective photograph. The types of works that can be protected through copyright are books, movies, TV shows and videos, software, scripts, photographs, drawings, paintings, sculptures, and sound recordings and music, such as the lyrics and underlying music of a song. But not everything can be copyrighted. Common examples of things that are not subject to copyright protection are ideas, procedures, processes, systems and methods of operation, because these are usually covered by patents. Mathematical principles and discoveries, historical facts, titles, names, and slogans, because those are usually covered by trademarks, short phrases, generally format and layout, a list of ingredients for a recipe, blank forms, and familiar symbols and designs. The term of a work depends on when and how it was created. For works created after 1978 and published, the term of a work created by a known author is the life of the author plus 70 years. For a work created by a company or a work for hire situation and published, the term is 95 years from publication. If a work is unpublished, the term is 120 years from creation. The requirements for copyright protection are as follows. Originality. The work must be independently created by the author. Creativity. Only a modicum of creativity is required. While the bar is low, there is a bar. And fixation. Fixation in a medium from which the work can be perceived or communicated. An unrecorded, extemporaneous speech, a live theatrical performance are not sufficiently fixed to be subject to copyright. But generally, in the United States, the minute you put pen to paper and create something original, you have copyright rights in that work. While registration is not required to have a valid copyright, a federal registration is required to sue for copyright infringement in federal court. Registration also creates public record of copyright ownership. A registration within 5 years of first publication is prima facie proof of copyright validity and shifts the burden of proof to the alleged infringer in a copyright infringement lawsuit. Registration can entitle you to statutory damages, meaning you do not have to prove your actual damages, which can be really tough in a copyright infringement lawsuit. You can also recover attorney's fees if the application for registration is filed before infringement or within 3 months of publication. It depends on the situation. There is a big misconception over what a work for hire means. A copyrightable work is a made for hire in only 2 situations. First, when it is created by an employee as part of the employee's regular duties. Second, when a certain type of work is created as a result of an express written agreement between the creator and a party specially ordering or commissioning it. For works for hire, an employer is the copyright author when the work is prepared by an employee acting within the scope of his or her employment, or an independent contractor, but only for certain types of work, such as collective works, audiovisual works, translations, compilations, tests, and atlases. For example, an independent contractor commissioned to author software code or design an artistic logo is not a work made for hire situation. First, the independent contractor is not an employee. Second, the work is not on the enumerated list covered by the work for hire statute. Copyright rights are referred to as a bundle of rights. These rights give you the ability to control the reproductions of your work, including exact reproductions or any imitation or simulation, or reproductions in different forms than the original. The adaptation of your work, including whether anyone can make a derivative work, such as a sequel or a movie based on a book. The distribution of your work, though this right is limited by the first sale doctrine, and the performance and display of your work, including playing or showing your work in public. Copyright protects expression, not ideas. Copyright safeguards the original expression of an idea like a novel or a song, but not the underlying idea itself, nor things like procedures, titles, or slogans. So while a book is protected, the plot concept may not be. You own a copyright the moment you create an original work. As soon as you fix your original creative work in a tangible form, like writing it down or recording it, you automatically have copyright protection. No registration is needed for it to be valid. However, in order to sue for copyright infringement, you must have a registration. Registration strengthens your rights. While not required, registering your copyright provides major benefits. It serves as proof of ownership and opens the door to statutory damages and attorney's fees in infringement cases. Also remember that work for hire rules are strict. You don't automatically own something if you commissioned it unless it meets the narrow work for hire conditions. Either the creator is your employee, or there is a written agreement for certain types of commissioned works, like audiovisuals or compilations. Copyright grants a bundle of exclusive rights. As a copyright owner, you control how your work is used. Reproduction, adaptation, distribution, public performance, and display are all rights that you can control. These rights let you authorize or restrict how your work appears in different media or formats. Now I'll pass it to my colleague Craig Cook to discuss patents and trade secrets.
What is a patent? A patent is a form of intellectual property that gives the owner the right to exclude others from making, using, selling, or importing the invention. It's important to know that patents are only country-specific. So in the United States, we have the United States Patent and Trademark Office that reviews, examines, and grants patents. If you're interested in getting a patent in another country, you have to file for patent protection in those other countries as well, because a patent is only enforceable in the country that grants that patent. I'm going to talk about 2 different types of patents, the utility patent and the design patent. A utility patent can be used to protect new and useful processes, machines, manufacturers, and compositions of matter. It's the most common type of a patent, but there's there's also design patents which cover the ornamental appearance of a product. And that is a really important form of intellectual property to protect the innovations that you've come up with. Well, a patent can be a very valuable form of intellectual property again. It's a form of property that protects your invention. So for example, if you want to prevent others from copying your invention, a patent is one of the most powerful and important ways to be able to do that. Or if you're ready to start disclosing your idea, say you've come up with a new innovation, you want to show it to potential customers, or maybe even at a trade show, or even talk about it with other potential collaborators for the invention, you need to file a patent application before you make those kinds of public disclosures, because those can actually prevent you from getting patent rights on your innovation if you haven't filed a patent application before you make those kinds of disclosures. But it's also important to know that you can actually use a patent to license your technology. So for example, you've come up with a wonderful innovation, but you don't really want to invest in the manufacturing aspects of it, or maybe there's another larger company who's already set up with a distribution or a sales force or manufacturing, a big company that you might want to license your rights to. Having a patent is the main form of intellectual property that you would license to that third party. Or for example, if you're starting out and you want to attract investors or increase your company's valuation, having intellectual property in the form of patents, trademarks that Jonathan talked about, etc., really can increase the value of your company and impress investors. By getting a patent, you can deter competitors from entering the market space. I mean, that's the best way to claim and protect your market space. Another really valuable thing that you can do with a patent is protect yourselves from being sued by competitors who might have patents that cover your products. They're called defensive patents, and you can get a patent that'll cover what a potential competitor is doing and kind of hold that on your own to be able to countersue them or even negotiate a settlement in case a competitor is suing you. So with a patent, you're going to have a cover sheet, and the cover sheet's going to have information on it like who the inventors are, who the owner of it or assignee of it was at the time that the patent was printed. It'll also have information on it like the patent number, the date the patent was issued, the date the application was filed, things like that. If it's a patent application, because the patent offices around the world, including the USPTO, the US Patent and Trademark Office, typically publish patent applications before they're granted. The patent application number will look different. It'll usually have a 4-digit number, like 2022, and then a slash, and then a series of numbers after that. And it's important to be able to tell the difference between a pending patent application that's been published and a granted patent, because only a granted patent can be enforced for infringement against competitors. A pending patent application just means it's being examined at the patent office and is not yet an enforceable legal property. But you'll also have an abstract, which is a short description of the nature of the invention, and a representative figure. But then you get into the heart of it, the drawings and the detailed description section of a patent or patent application. And the drawings will typically lay out the main modes or embodiments of the invention, like the physical structure or the method of operation and use. Maybe even if it's a manufacturing method patent, might have pictures of the method of manufacturing. And it should also include alternatives, like other ways of doing it, not just the principal embodiment or way of doing it. And the detailed description is also going to match that. But a good way to do this is the figures will typically tell a story of what the product does, how it functions, and what it entails structurally. And the detailed description is going to fill in a lot of those additional details and a lot of the additional information that you need to know to understand exactly what the inventor is disclosing in the patent application. It's important to note that when a patent application is filed, it can't be changed after filing. The only thing that can be changed is you can alter the claims discussion. There are some changes you can make to the description, but basically you can't add any new matter to a patent application after it's been filed. And this is important because you want to be able to time it right. If you're developing a product and you feel like you're at the point where you're ready to protect the patent application, just know that you have to kind of think forward in terms of what you're going to try to protect with the patent down the road, because after it's filed, you can't add any new details to it. And this becomes a very important thing. You know, the way the USPTO works is the earlier you file the patent application, probably the better chance you've got of getting a patent issued on it, because it's called a race to the patent office. The earlier filed rights, or even, you know, if a product comes out before you file your patent application, or if somebody else files a patent application on the same technology before you do, they're going to have superior rights to yours. A product that comes out before you file your patent application is going to be considered prior art, which can prevent you from getting a patent on that same technology. So there is a little bit of a time concern. You do want to file as early as you can, but just know that you can't add new details after you've filed it. The main part of the patent or patent application that define the metes and bounds of the legal protection that's afforded by the patent are the claims, and they're typically at the end of the application or end of the patent. And those are going to strictly define exactly the scope of the invention, or the scope of the protection that's afforded by the patent. And that's the most important part to focus on if you're looking at whether or not your product might actually infringe somebody else's patent, or what you're trying to protect that's different than what the prior art or everything that happened before you filed your patent application covers. So you have to be able to distinguish the prior art by having something that's novel and non-obvious. When examiners look at a patent application to determine whether or not it can be granted, they're going to focus on the claims and make sure that those claims describe the invention that is novel, non-obvious, et cetera, over the prior art. Okay, so how do you get a patent? So the first step in the process, prepare and file a patent application with the United States Patent and Trademark Office. And if you're interested in getting protection in other countries, there are systems in place that allow you to actually use your US Patent and Trademark Office application to claim priority and actually get protection in other countries. If you filed in those other countries within a year of when you file your US PTO application, you can claim priority back to your US PTO application. So the main way that most inventors start is by filing a patent application in the US only, and then within a year you can start looking at filing in other international countries if you're interested in. But most important markets are the ones that you'd focus on, and the US tends to be the highest on the list there. So after you filed your patent application, it'll sit at the patent office. Once an examiner picks it up and they start examining it, again, they're going to look at the claims to see if your claims are novel and non-obvious. Your attorneys will be able to help you through this process. And so you really want to know what you're up against before you start that examination process. And it's particularly important for patents because, as I mentioned earlier, after you file a patent application, you can't add any new details to it. So for example, you think of, oh yeah, ours does this that's different than the prior art. That has to be disclosed in your patent application to be able to argue that to the examiner and show them that you are novel and non-obvious over the prior art. And so if you have gone through that process and the examiner agrees that you are patentable over the prior art, then you're going to get what's called a notice of allowance. And from that point, it's just administrative steps to basically get a granted patent, pay some fees, and then you'll get a patent issued by the patent office that'll have a patent number on it, the name of the inventor, the company that owns it, or individual that owns it, if that's the case. Additionally, to maintain a patent throughout the life of the patent, you have to pay maintenance fees in the US, or internationally, they're called annuities, to maintain the enforceability of a patent after it's been granted. An important question that I often get from innovators or companies or anybody starting out a new product is, well, if I've got a patent, does that protect me from infringing somebody else's patents? And the answer is clearly no. So as I mentioned earlier, a patent gives you the right to exclude others from making, using, selling, or importing your invention. It doesn't give you the right to practice the invention. They call that freedom to operate. A patent will not give you freedom to operate. You still have to consider whether or not the product that you're making might encroach upon or be covered by the claims of a third party or a competitor's patent. So for example, say you're developing a carbon fiber bike frame. Say you filed a patent application 13, 14 years ago, and now you've got this patent on that. Can you make that carbon fiber bike frame without infringing anybody else's patents? Well, the answer isn't necessarily yes. Even if your innovation in that carbon fiber bike frame was patentable and was patented, there might be somebody else that's got a patent that covers carbon fiber technology generally, or somebody else that's got a bike patent. If there's a patent on a bike, even though yours is an improvement on the bike, you went from aluminum to carbon fiber in your innovation, somebody else might have a patent that covers a bike. So you have to consider still whether or not you're infringing on third-party rights before you start manufacturing new and innovative products, even if you have a patent. If you think you have something novel and non-obvious, something pretty innovative over every other product that you've seen out there, and you want to be able to protect your market share, protect the time and money that you've invested in that product, that's when you start thinking about filing a patent application. But there are things that you can do on your own before even contacting a patent attorney to really research whether or not there's a potential for patentability. Google Patents is a common platform that a lot of inventors will use to kind of get a sense for what other patents are out there. Even just doing Google searches to see if there have been published papers or if there are other products out there that are similar to what you're trying to invent or what you're trying to patent. That's all useful information to understand, and you can do a lot of that work on your own. The USPTO has probably the most powerful patent research or search database. If you get comfortable using that, that's a really good way to find other patents that are published applications that might cover your technology. But the most important thing that you need to know is if you make any kind of a public disclosure, for example, at a trade show conference, potential customers, try to get a non-disclosure agreement in place before you do that, but definitely get a patent application filed before you do that. Because not only can those third parties potentially use your invention if you don't have the protections in place, but the bigger thing is those can actually create what are called patent bars. Public disclosures can prevent you from actually getting a patent on your own invention if you've disclosed that to somebody and haven't filed a patent application, either in the US within 1 year of making any of those public disclosures, or in most countries outside of the US before you actually make those disclosures. Well, the first call you should make is your patent attorney, because they're going to want to look at whether or not your patent actually covers their invention. We have a lot of experience also with enforcement and have learned a lot of things along the way that hopefully we're sharing with you now that'll help you figure out what the timing is, how to handle it, and what to do. Say, for example, you've got a product that's got a really neat ornamental design to it, and you think that it's really unique on the market, and somebody else might be out there copying it. A design patent would be the best way to do that, and enforcing it can be as simple as sending a letter, like a cease and desist letter, to a potential infringer, letting them know about your patent rights, putting them on notice of your patent rights, and basically telling them to stop, or else they're potentially going to face legal damages, a lawsuit, etc. That cease and desist letter is often the first step in negotiating or preventing a competitor from using your idea. Litigation down the road, that's if other forms of mitigation aren't resulting in any kind of success for you, then you might look at litigation. When you see those competitor products on the market that are potentially infringing your product, that's when you give your attorney a call. The things that you want to look for is it doesn't have to be the entire product. Even one feature that's novel and non-obvious and is important, for example, for the marketability of your feature. Say there's something that really distinguishes your feature over what other competitors are selling. If that's an important feature and you don't want anybody else copying it, that might be a good one to look at potentially protecting if it's novel and non-obvious. So an important question is, how much does a patent cost? And I think it's really important to be thinking about this early stage, because patents are expensive to get. And it depends on the level of complexity of the invention and where you want to protect it. If you want to protect it in the United States only, it's going to be a lot less expensive than protecting it internationally. But it's a good thing to think about early on, because it certainly does require either an investor or a certain amount of your budget set aside to protect that intellectual property, that patent. And I think it's really important to start figuring this out early. It's hard to give an exact number until you start really understanding the complexity, the technology, how much prior art is out there, whether or not, again, you want to look at international protection, things like that. But I think once you've met with the patent attorney and you've given them a little bit of information, they can give you a pretty good idea of what the cost is. But I will say the cost is not insubstantial, but it's probably one of the best investments that you can make in your company if you have innovations that you want to be able to prevent other competitors from making. There's a limited term to a patent. Patents typically have a 20-year life from the date that you file a patent application, and during that life, after it's been granted, you can enforce it through those 20 years. They can't typically be extended beyond that, and after that, the innovation or whatever's disclosed in that patent application becomes part of the public domain and anybody can use it. Number one, I mentioned that the patent office in the United States and pretty much everywhere internationally is a first to file, so it's kind of like a race to the patent office. So you want to be able to get your patent application on file, even if it's an early stage patent application, what we call a provisional application. You can get those on file pretty quickly, and that's probably the best way to start. Number two, and sort of a related point, make sure you file that patent application before you make any kind of a public disclosure of your invention, either online in social media, in person, or an offer for sale. Number three, patents can be extremely valuable for protecting your market share, from preventing competitors from getting in and basically taking advantage of all the years of research and development and innovation that you've put into developing a product. That patent can help you prevent them from being able to jumpstart right to that point and compete with you on that level. Number four, patents can also help you when you're looking to raise capital from investors and everything else. Patents also look good from a customer standpoint. Patented technology seems more impressive than non-patented technology, so it's a good marketing scheme as well. One last really key takeaway point are on design patents. Design patents are typically a little bit cheaper, a little bit easier to get, and they provide very powerful protection. So design patents, as I mentioned earlier, cover the ornamental appearance of something. A lot of the consumer products that you use every day have design patents on it. That's something to keep in mind. Always consider design patent protection when you have some ornamental appearance of your design that you want to prevent others from copying. So I've talked about patents, which have a limited term. Now we're going to talk about trade secrets. And what is a trade secret? A trade secret is another form of intellectual property that gives you the right to protect confidential information, which actually can be sold and licensed just like a patent or other forms of property. But they're only used to protect information that isn't known by the public, things that you take reasonable steps to protect. So a trade secret can be used to protect, for example, internal manufacturing methods or some new material that you don't think others can independently develop. Common trade secrets that you might know of are the Coca-Cola secret formula or KFC secret recipe, but even things like different types of materials that you might develop or software algorithms, as long as you're able to keep those in a black box and prevent those from being publicly disclosed, those can be trade secrets. But just remember, if something is independently developed by some third party or somebody else, that's the same as what you're trying to protect, then that trade secret protection goes away. The main thing is that you have to take reasonable precautions to protect that information from being publicly disclosed. So for example, if you've got a manufacturing method that you think is probably the most efficient or the best way, or maybe even the only way to make a particular product, you want to be able to protect that information with a number of steps. Number one, preventing unauthorized exposure or use to that information. For example, are customers coming through your warehouse? Are they able to see that? If they are, that can prevent you from getting trade secret protection. But if you enclose that, close it off so that only the people that need to know that information have that information, and take some of the other steps that I'm going to talk about in a little bit, then you're going to be able to protect that trade secret information and protect misappropriation of that. So a common way that trade secret information is misappropriated is when employees leave. So you've traded an employee, they've been exposed to your secret, your proprietary technology. Trade secrets can prevent them from using that technology and joining a competitor's business and using it to that competitor's benefit. It's important to know that trade secrets do not protect against information that is either publicly known or independently developed or even reverse engineered. So if you've got something, a product that you're making, and somebody can take it apart and figure out how you made it without really having access to your internal trade secret proprietary information, if they can reverse engineer it, then that's going to eliminate your ability to protect against the misappropriation of that trade secret information. So that's kind of the trade-off between patents and trade secrets. With patents, you have to publicly disclose it, but then you're able to get a kind of a monopoly on that invention for a period of 20 years from the filing date of the application. But with trade secrets, you have to prevent that information from being publicly known, etc. Or if you think that somebody else might be able to independently develop it or reverse engineer that trade secret information based on a product that you sell or anything you publicly disclosed, that it pretty much eliminates your ability to get trade secret protection. So you don't have to apply for a trade secret, or it's not something that's granted by the government. It's typically something that you get by putting in reasonable precautions to some valuable information that your company owns. And it's got to have economic value to your company. But again, it could be the things like customer lists, manufacturing methods, things like that. But you have to take efforts that are commensurate with the value of the information to protect that. So for example, some of the things that we always recommend, clearly identify information as being proprietary and confidential on any documents that you might have that describe it. Prevent any employees from accessing the information unless they need to know it to perform their particular roles. Keep that information protected in a way that isn't accessible by anybody. Clearly making sure that anybody that might enter your facility isn't exposed to that trade secret information. That's really very important. But you can also take steps like in employee agreements. These are very important. You've got agreements with your employees to protect that confidential information. So before they've even started, before they've even been exposed to any of this trade secret information, you've got an employee onboarding process that has an agreement to keep all that information secret. You've got an employee handbook that outlines what the steps are that they need to take to protect that information, maybe even controlling access to those particular areas. The handbook should have a pretty good range of different things that each employee must understand and agree to in order to protect that trade secret information. Even on the outboarding side of things, say you have an employee leaving and you're having an exit interview, remind them of their responsibilities. Remind them of the agreements that they've signed. Make sure that they understand that everything that they've learned that's confidential and trade secret proprietary information is something that they cannot share with any competitors or anybody else on the outside that they might go to. So giving them a copy of that non-disclosure agreement, confidentiality agreement, or employee handbook even, and reminding them of their responsibilities is another really good way to prevent employees from taking that information and going to competitors with that information. Keeping the information in a secure location. I talked about that before with a manufacturing method, but it might be, for example, in your databases, in your files, things like that. Makes things password protected, or make things accessible only to the employees or people that you work with that need access to that information. That's another way of showing that you've taken reasonable steps to protect that. It's all really, truly common sense stuff. You're taking reasonable precautions to prevent other people from getting this information, period. And that also goes to help support the value and the enforceability of a trade secret. So just in closing, you might want to think about, how do I decide between a patent and a trade secret protection? And again, I think most companies have a combination of two. Typically, company know-how that isn't included in a patent application, things like customer lists or even just intricacies of manufacturing methods, things like that. That's all going to be trade secret information eligible as long as you're protecting it with those reasonable security type precautions. But if it's information that you want to make sure you can protect, even if a third party develops that independently, or if it can be reversed engineered from your own products, then you might consider filing a patent application on it, knowing that you still have that limited term, and then after that it becomes part of the public domain. But if it's something like internal methods or something that really a third party is never going to really have access to or exposure to, or if you don't think there's a good chance of them being able to reverse engineer or develop it on their own, then trade secret protection is a pretty good way to go. Also, one other point is, if you think there's a risk that your invention could be publicly disclosed, then you're going to want to consider a patent protection for it. And of course, how long that protection is valuable. Things in the computer technology tend to evolve very, very quickly. And patent protection might be more valuable than trade secret protection there, because a 20-year term is probably a lifetime for something in that space. All right, so the top takeaways regarding trade secrets. I think, again, just make sure you're employing reasonable precautions to protect the secrecy of that information. All the type of common sense stuff that you would normally do to prevent your information from being used or taken away from your company, take that to a next level, but consider all those steps that you would make and document those steps. Make sure that you've got all of your non-disclosure agreements signed by the people that are receiving that confidential information, and prevent others who don't need to have access to that information from getting access. I think that's probably one of the best ways to protect your trade secret technology. Thank you so much for listening in. Jonathan and I really enjoyed sharing our knowledge of copyrights, trademarks, trade secrets, and patents with you. And we hope that this offers a great resource for you and your company going forward.
Contact Betzedic's Small Business Development Project by visiting lalegalhelp.org or calling 866-375-9511.